This is a big win out of the Supreme Court of the United States. Will, let's break down this case because this is the important one. This is one about the judges. People have been concerned about the judges having way too much strength to shut down a president's agenda. And it looks like, and we'll get into the nuance of it, but it looks like we were right in that situation.
That's right. So this case, and you'll see in the headlines if you're reading online and everything, the birthright citizenship case is what all the media is putting the headlines behind. But in reality, this had nothing to do with the merits of that case, with that executive order on birthright citizenship. What the government took to the Supreme Court was the issue of these nationwide injunctions. Basically, a district judge being able to completely halt the executive branch's policy in perpetuity with just the stroke of a pen by issuing an order saying this is a nationwide injunction while it goes through the court system.
And over and over again. We saw it unlike any other presidency in history, where all of a sudden, every time President Trump went to go make a move, a random judge, was what it felt like, a random judge in a random district could halt it all. And of course, the American people eyes were opened, and they said, this can't be how it's supposed to be. And Supreme Court, in a 6-3 decision, correct?
That's right, 6-3 decision. This was authored by Amy Coney Barrett. The dissenters were Justice Sotomayor, Justice Kagan, and Justice Jackson, the three liberal members of the court. And in what Barrett's opinion held was that some say that universal injunction gives the judiciary a powerful tool to check the executive branch. But federal courts do not exercise general oversight of the executive branch. They resolve cases and controversies consistent with the authority Congress has given them. We're going to go to Chief Counsel of the ACLJ, Jay Sekulow. And what is your first thought on this very important case?
This is a big win for the administration. It's a big win for us. In fact, the argument that we put forward was used in large part by Justice Barrett in her majority opinion. And here's what the court said. So you've got a situation where the president's executive actions and other actions were being challenged by citizens of various locales. And then the court, instead of saying, well, we'll apply an injunction as to those people, they were doing it for the entire country. And there's no precedent in our history, and this is what Justice Barrett pointed out, and we pointed out too. There's no precedent for this action. Zero. None. So when you look at it that way and realize what's at play, this was a 100% victory. It stops these rogue judges from issuing nationwide injunctions. I mean, a U.S. District Court judge could stop the administration dead in its tracks for the whole country. And the court said that's not the way our system is set up. That's not the way jurisdiction is set up. That's not the way the Constitution works.
And when you look at the ruling, and I think this is important for the audience to hear, because we think of Supreme Court arguments, you hear the two sides deliver oral argument, but as you say many times that a lot of times the Supreme Court decisions aren't won during the oral argument. And that is why at the ACLJ we engage in these types of filing amicus briefs, putting forward the briefing for the justices, which is a large part of how they write their opinions. And when you see in this one, the arguments the ACLJ was making about Rule 26 of the federal judiciary, as well as even some of the phraseology like the historical pedigree that was used in the opinion was a phrase that we were using in our own brief, you can start to understand why the briefing is so important for these justices as they come to their opinions on the law.
Well, that's exactly correct. And look, we've been at this for 45 years, and the truth of the matter is this: our briefs are frequently cited by the courts, utilized by the courts, and this was a perfect example of it. It came out exactly as we anticipated, and we were hopeful for, and it's the perfect decision in the sense that it curtails the ability of these judges to stop the administration's actions for the entire country. They could do it for their district. They can't do it for the plaintiffs that's in front of them, but not for the whole country. And that makes a big difference in how these things move forward.
Yeah, I wanted to talk about that too, because this is something that's going to be setting precedent. A lot of people think about the fact that President Trump is currently in office. This is President Trump. This isn't just for President Trump. This is for future Republicans and Democrats, because if you could play this game, it will be endless. It would have been an endless battle for every administration, maybe for the history of time at that point, where nothing could get done. It's another way that these judges and really, honestly, the activists can figure out how to stop even what the American people are voting for.
That's exactly correct. And here's the reality of what's happened. This put a check on the judiciary, which again coincides with the constitutional directives of a unitary executive. The president makes these decisions. A judge could stop it, but only for their district. No more universal jurisdiction. It wasn't good if Republicans did it. It's not good if Democrats do it. It should not happen.
So overall, because of course, if you start reading one of these wins, you start reading one of the opinions from the Supreme Court, if you're not used to reading the opinions, it can get a little murky. So I was reading it, starting to read it, and I jumped to the bottom to go, okay, who voted for it? Because I think that can be a pretty good indication of who voted for what, and whether they were being a little bit more nuanced in it. But for those who are just reading this, what I guess would be the big win takeaways, and is there anything we need to be looking out for in terms of the way these opinions are written?
Well, the big win takeaway is that a judge cannot stop an individual judge can't stop the actions of the administration for the entire country. That's over. So this judge shopping that they're doing is finished. And that's really important. And what this means is the president can exercise his authority under Article 2. The court's Article 3 authority is checked in the sense that their jurisdiction is limited to what Congress authorized. Congress did not authorize universal jurisdiction. There was no history or precedent. It's over.
Sometimes, as Logan's was talking about, you read, and especially when the opinions are rooted in the law and they are going through the history and things, sometimes you do have to parse out, okay, how big of a win is this? Is this very limited to this one case, or is it broad? But sometimes you can jump to the dissents and get a real full picture of how big of a win it is based off how upset the more liberal, philosophically minded justices are. And I wanted to read this from Justice Jackson's dissent, who has actually surprised us many times by voting in the way of the conservatives, especially on the immunity decision where she was joining the conservatives in that. But she had this to say about this opinion. Perhaps the degradation of our rule of law regime would have happened anyway, but this court's complicity in the creation of a culture of disdain for lower courts, their rulings, and the law as they interpret it will surely hasten the downfall of our governing institutions, enabling our collective demise. I don't think I've read something so apocalyptic in a dissent before, but maybe I'm wrong.
Hilarious.
First of all, okay, it's a procedural decision. Okay, and it's a good procedural decision. It says courts can exercise universal jurisdiction. That makes total sense. But to say this is the end of the rule of law, we know it, is nonsense. I mean, totally incorrect. Great decision by Justice Barrett. Good win for the administration. Good win for us. We're thrilled.
And I want to hear from President Trump, because I know that he has been speaking about this. Do you want to play something from Trump?
Let's go ahead. This is from the press conference. He
moments ago
announced early, as soon as this came out, this decision by the Supreme Court, that there would be a press conference with him and the Attorney General.
Elected on a historic mandate, but in recent months we've seen a handful of radical left judges effectively try to overrule the rightful powers of the president to stop the American people from getting the policies that they voted for in record numbers. It was a grave threat to democracy, frankly, and instead of merely ruling on the immediate cases before them, these judges have attempted to dictate the law for the entire nation. In practice, this meant that if any one of the nearly 700 federal judges disagreed with the policy of a duly elected president of the United States, he or she could block that policy from going into effect, or at least delay it for many years, tie it up in the court system. This was a colossal abuse of power which never occurred in American history prior to recent decades, and we've been hit with more nationwide injunctions than were issued in the entire 20th century.
We worked with the Attorney General's Office of West Virginia, and in the brief that we filed was on behalf of the state of West Virginia. So both the Attorney General and his Solicitor General, as well as our team's names, are all on the front of the brief. And the brief of amicus curiae state of West Virginia in support of the applicants is the title of our brief. So it's a win for not just the ACLJ and all of our members, but as well as a client in this, the state of West Virginia, that was concerned about the implications of these district judges, not just on the administration, but how people could then go and forum shop to get nationwide injunctions to try and block things that individual states were doing and trying to almost have state warfare, economic warfare or lawfare against other states by the way that injunctions could be placed and handed down.
We are so excited to announce the ACLJ's brand new app, completely redesigned to provide you with the best tools available to partner with us at the ACLJ. You can watch the daily Secular program, sign the petitions, customize your ACLJ membership experience, donate with the click of a button, and receive up-to-the-minute critical updates that the mainstream media can't censor. Just scan the QR code on your screen or go to your phone's app store, search ACLJ, and click install. It's that simple.